Mr. Frazier is here today after failing to appear before this court on August 30th, 2023. Bond is currently set at $2,881. This is the first bench warrant. He reports no employment. The last payment made on this account was on March 20th of 2024. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 24th, 2024 at 8:45 a.m. before this court.
Mr. Frazier, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on April 24, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I don't have any money. Today was supposed to be my last day painting for a friend of mine, and he's willing. I don't know what he'd be able to do for me. He's the one who, if you guys do release me, he's the one who's willing to pick me up. On the 21st, I'm supposed to be in Michigan City to start working for North American Midway Entertainment at 25% commission. That's where I was working last August, September, October. And that's when I was able to make a couple substantial payments of like 1,500, but I only worked there for those 2 months. And so this season I was gonna do the whole season, and every 10 days we would get paid, and I'd be able to really knock that down or just take it all the way out. But
well, you owe a sizable amount of money.
Yeah, but like literally I'd be able to probably pay about 1,000 every 10 days. So I'm pretty sure I'd be able to knock it out pretty easily if all I gotta do is make it to Michigan City on the 21st, and then we go right on the road immediately.
Yep. Well, what the court's going to do is I'm going to reduce your bond. It is your first bench warrant, so I'm taking that into consideration. I'm going to set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
So anyway, you could put it like 100.
No, I actually was going to initially set it much higher than that, and I cut it down to give you some consideration.
I appreciate it.
Okay, thank you. You're free to go.
Thank you, sir.
That's all I have today, Your Honor. Thank you.
Thanks. Court will note the appearance of Ms. Greenlee-Clore on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for repayment of overpayment of child support. I've read the pleadings, Ms. Greenlee-Clore. Is there anything else you have to add?
The only other thing I have to add, Your Honor, is looking back at the documents, the calculation, first of all, Ms. Chilton is an intelligent woman. She knows how child support works. The child support calculation that was giving her so much child support had her income at $15,000 per year. When we recalculated child support, the child support was at $50,000 per year for Ms. Chilton's income. And that was what it was recalculated on. There's no way that Ms. Chilton knew, or there's no way that she did not know that child support shouldn't have been at that level that it was at. And I don't know that's not up for debate today because it's already been modified. But at this point, my client's kind of stuck where he's overpaid child support for years, essentially, to Ms. Chilton, but he has no way to get any of that child support back. And as our motion indicated, he tried to pursue this. It didn't come back. And I think what we need to do is we probably need an order from this court with how this is supposed to get paid so that if he does need to, he can pursue collection action. Okay. Thank you, Your Honor.
Thank you. Ms. Chilton, what's your response?
Good morning. At the time when this was calculated, as I presented to the court, I was only working part-time, and the order was based on that part-time work ending in that summer of June or whenever that school year ended. And again, as I put in my answer, that I was not going to be working over the summer because I was going to school. And then once I went back to work in August, which I did have a full-time job at that time. That is when I submitted the documentation to the child support court that I was, in fact, earning more money. So I did submit documentation. I didn't understate any income. We had to submit documentation to the court at that time to prove my income at that time. And so I don't feel like it is at my fault that that the child support stayed in that way. Once I submitted documentation to the court of my full-time employment, it had not changed, so I took it back to the court. I submitted it twice, as you will see in the documentation and supporting evidence that I did submit this documentation to the court twice. So I submitted, I did everything that I knew to do. I was not trying to be deceiving in any way. I submitted the information that I had, that I knew that I needed to submit, and that income was based on him working more at that time, and then he went on to a different job that caused him to make less. So the recalculation, I'm not sure where the $50,000 is coming from, but again, I was not working prior to that due to COVID. And then I started working part-time, and the childcare that I was asking to be paid for at that time was not being paid for. So that's when the child support came up, because he wasn't meeting his obligation that we had agreed upon.
Okay. Well, in this particular case, I'm not going to address the issue of the amount of support, because that was changed and it's already been resolved. I understand the arguments, but it would be inequitable to charge the plaintiff an amount, and again, that would in essence have him paying over $7,000 that he should not have had to have paid had it been calculated at that correct amount at that particular time. So the court is going to grant the motion for the repayment. Screenly Court, what I'm going to do is order that the amount of $6,891 would be repaid over the same term that it was collected. So if it was collected over, I think you said over 12 months, then that would be repaid over 12 months. If it was longer, I just don't know, based upon the pleadings that are filed, over what time that was collected. So I'll simply order that you can figure it out when it was collected and then have the repayment over the same term.
Your Honor, so just to clarify, dating back, so the court backdated support to March of 2022. Are you saying March of 2022 to today would be the repayment period?
No, I'm saying the time that he paid the overpayment, that the repayment would be over the same term. So if it was 12 months, if it was 18 months, I don't know, from the time that he began paying that $764 and the time that it changed to the $34. So it would just be repaid over the term that it was paid.
Okay, and equal monthly installments, Your Honor?
Yes.
And then no, we also made a request for attorney fees in this case. Is that
I'm not going to award attorney fees in this case.
Okay.
It sounds like there were enough issues and problems in the case to go along. I don't hold anybody responsible for that.
Okay, thank you, Your Honor.
Okay, thank you. You're free to go. You can submit that under 7 days.
Thank you.
Court will note the appearance of Ms. Reed on behalf of plaintiff, Ms. Henderson on behalf of defendant. This matter is before the court on the defendant's motion to hold plaintiff in contempt and for immediate resumption of parenting time and other relief. Ms. Henderson, obviously we have a substantial docket today. I don't need a rehashing of everything. We do have an answer filed in this matter, which denies the allegations. Therefore, the court's going to have an evidentiary hearing. Is there anything else that you have that we can address today?
No, Your Honor. Essentially, what we're asking is that the consent order that the parties entered into prior to this hearing continue, meaning the parties continue counseling with Meredith Katz and follow all of her recommendations. We would ask that the issue be scheduled for an evidentiary hearing to consider the issues brought up in our motion. Ms. Katz expressed significant concerns regarding coaching of children by the mother. So that is the issue we would like to be brought up at the evidentiary hearing. I would also ask the court to remind the parties that the order has not been changed, so it should be followed as it relates to the parenting time. Thank you.
Okay, thank you. Ms. Reed, anything else other than your answer?
Just that the children are continuing to refuse to go over to dad's home. My client is not denying parenting time. It's that these children are refusing to go, and they're at an age where she cannot physically force them to go. The counseling with Ms. Katz has just recently started. She's had maybe 3 appointments with them. Joint sessions have not started yet, and they're still starting to identify what the issues are of why the children are refusing to go over to dad. So I believe a show cause is kind of premature, so we're asking for it to be denied.
Okay. Well, I do believe that there's a sufficient basis to proceed. The court will schedule an evidentiary hearing, but I want to get some input from the counselor, so we'll schedule the evidentiary hearing after we get a report from the counselor. The counseling in this matter will resume, and it will be in person. I know that there was some issue about, well, doing it Zoom. I wanted in person, so we can put that in the order. Court would order further that the defendant's phone number would be added to the children's phones in this case. The court will reserve on the balance of the other relief, but I would state, if it's determined, Ms. Joswiak, that you are not attempting to facilitate the children going to the defendant, the court will order makeup for all of the parenting time missed. And I just had that happen in a case in which we found out that the mother was not facilitating that. So dad was given about 6 months straight of parenting time. So just want to let you know that the court could, in this matter as well, hold you in contempt and incarcerate you until such time as the children do go. So I'm mentioning that, but that's how we'll proceed. Now, Ms. Henderson, I'll ask that you would prepare an order, submit under 7 days.
Sure, Your Honor. As for report of the counselor, Meredith Katz prefers to testify in person or by Zoom at the hearing. Would that be acceptable to Your Honor?
Yeah, she doesn't have to appear at the hearing at that. She can
That's her
appear by
preference.
Zoom.
Yeah, she usually likes to testify at the hearing rather than prepare a report. She does give updates to the counsel via email.
Okay, I don't know. I don't understand what you're asking for then.
Your ruling stated that the evidentiary hearing shall be after Ms. Katz submits a report.
Yes.
So I'm following up on that because usually she testifies at the hearing rather than submitting a formal report to the court.
Well, have her submit a report, and then we'll be able to see what, and then we can, that way it can tell us, kind of give us some ideas to parameters of the hearing.
Okay, thank you, Your Honor.
Okay,
And
thank
would
you.
the hearing be with you or with the referee?
No, it'll be with me.
Okay, thank you
Okay,
very much.
thank you.
Appreciate it. Have a good day.
Bye. Court will note the appearance of Ms. McNiff on behalf of plaintiff. This matter is before the court on the plaintiff's motion to modify custody, parenting time, and support. Ms. McNiff.
Your Honor, I know the court's busy today. We're asking to modify the sole legal to modify legal custody to sole legal with my client. Mr. Van Zant simply hasn't complied with the court's previous orders. The children don't have an appropriate place to live, let alone stay when they're at the dad's house. They don't have bedrooms. They don't have clothing. They don't have personal hygiene items. He's living either in a camper at his friend's house or in the friend's house. Also, child support had been suspended because Mr. Van Zant said he was applying for disability. We've received no information about that. But as I indicated in the motion, Mr. Van Zant has the ability to walk from Marshall to Battle Creek, which calls into question his ability, whether or not he's actually disabled. So we're asking the court to unsuspend child support and also to allow me to calculate child support based on 0 overnights, because the children have had maybe 1 overnight with dad in the camper when the weather was appropriate. We would also ask that dad be required to arrange any parenting time with mom and not go through the minor children.
Okay, thank you. Mr. Van Zant, what's your response?
Yes, there's a few of those I would like to address. Yeah, I don't have the clothing and stuff, but the hygiene products are there. I have walked to her house a couple times, but not without consequence. My ankles bleed every time I do it, and I'm down for days afterwards, but I will do it to spend time with my kids when I'm able to. My disability hearing is still in process. I'm waiting for the paperwork for my video hearing for it. That paperwork was sent in. I'm waiting to hear back. I got your information or your letter for medical affidavit, which I got to my doctor. I'm just waiting to get it back either today or tomorrow. Let's see what else. And the mailing address that they put on there is wrong because my address has been changed from her house for a couple years now, since I lived on 15 Mile Road. What else is on here that I would like to address? But yes, basically they are right though, because I am unable to work at the moment, but I have walked to their house a couple different times throughout the year to actually be able to see my kids, because she won't bring them over to me when she's able to. Other than that, I guess that's about right, I think.
Okay. Well, the court does find in reviewing the pleadings that there has been threshold of proper cause or change in circumstances pursuant to Budvarka versus Grassmeyer for a hearing in this matter. The court will refer the matter to the referee for a hearing on the petition. The court will, in the interim, because we're not going to wait indefinitely for a determination on your disability, we can always go back and modify support if it turns out I'm going to vacate the suspension of child support at this time, effective today's date. I'll ask, Mr. Van Zant, you can notify Ms. McNiff after this hearing, call her office and give her your new address so that she makes sure that all the pleadings go to your correct address.
She has my correct address because their letter was mailed to where I'm staying.
Well, you were just stating they didn't have your address, so
I
that's
was
why I
meaning on
brought
the
it up.
paperwork. I was meaning on the paperwork. It says I've been using her address as a mailing address, and my address has been changed before this hearing, way before.
Well, that's not unusual. People move and the address on the pleadings is different, but she apparently sent it to the correct address. So that will be the order. Ms. McNiff, we can refer the matter to the referee in this particular matter, so that we'll take care of that.
Thank you, Judge. Do I need to do an order about,
Yeah, you'll need
suspension?
you'll need to do an order about vacating the suspension.
I will. Thank you, Your Honor.
Okay, thank you.
We'll note the
Here you go. Have a Todd on behalf of the plaintiff, Mr. Zubek on behalf of the defendant. This matter is before the court on the plaintiff's motion for contempt, and the court has received an answer as well. Have you received the answer, Mr. Todd?
I have, Your Honor.
Okay. Obviously, they're disputing the petition, so the court is going to have an evidentiary hearing in this particular matter, which I intend to do. Is there anything else that you want to address at this time, Mr. Todd?
Your Honor, I guess just clarification that the current order would remain in place, obviously pending this. And so this has been an ongoing problem, and the interim between now and whenever we have an evidentiary hearing is also a concern.
Okay. Mr. Zubik, anything that you have in addition to what's in your response?
No, thank you, Your Honor. And again, I apologize for the muting issue, but no, we have nothing further at this time.
Okay. Well, in this case, the court will order that the defendant cease communication except as specifically and concerning the children. So as much as it's, he likes to quote scripture, etc., that's not appropriate in addressing the issues concerning the children. For instance, if you have an issue concerning the time of pickup and that, I don't need to quote scripture or anything else other than to ask about that time for exchanging the children. So the court would find that all that is extraneous. It doesn't specifically address the children, no matter what he says as it relates to his desire to have transparency. Maybe it's too transparent and it's not appropriate. So court will set the matter for evidentiary hearing before the referee, and will reserve on the attorney fees as well. Anything else, Mr. Todd?
Nothing further, Your Honor. Thank you.
Mr. Zubik?
No, thank you, Your Honor.
Okay, thank you.
Thank you.
We'll do an order on that, Mr. Todd. You don't have to.
Okay, thank you, Your Honor.
Okay, thank you.
860
Thank you, Your
Ashley
Honor.
Morris versus Joshua Williams. This was a gentleman that called in.
Yep. Court will note that it is now 9:25. The matter was set for 9 o'clock. We did get a phone call from the defendant saying that he may join later. Unfortunately, his matter is set for 9 o'clock. It's on plaintiff's motion regarding vacation and holiday time. I've read your motion, Mr. Todd. What the court states that the court does believe it's appropriate in the view of the, again, the activity the client wants. The court will grant her the weekend of 4/19 to go to Florida. The court will also provide for, I don't have any issue with the other provisions that you suggested in paragraphs 7A, 7C, 7D, and 7E. You can put those in the order. I will not order the other provisions that you wanted in the order.
I apologize, Your Honor. Can you repeat that?
7A, 7C, 7D, and 7E.
Okay.
As well as the next weekend of the 19th.
Okay, absolutely, Your Honor.
Okay, you can get that in, and Mr. Todd, if you get that to us today, we can get it signed today too.
Okay, absolutely. I'll do that.
Okay. Thank you. That will conclude this matter. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you.
Court will note the appearance of Ms. Paisno on behalf of the plaintiff. This matter is before the court on the plaintiff's notice for entry of consent order affiliation. You heard Ms. Payne, know that the defendant had called or something and wanted to request an adjournment. Had you talked to him or?
Your Honor, I received an email through my assistant this morning that he sent on Saturday at 2:22 in the afternoon, just saying that he just got back from Minnesota. He's been gone for the past month, and he just needs to get caught up on stuff, and he needs time to get a lawyer so he can start back working on this again today. The issue is that DNA testing was done, and all I'm trying to do is get him deemed dad in an order of affiliation, and I can't get a signature on anything. So I'm just asking this court to at least sign the consent order or an order of affiliation naming him legal and biological father, so then we can move forward in this matter.
Well, you say consent. Did he consent to it?
He consented to the DNA test, but he has not consented to this order, no.
Okay.
This is the first time I've heard from him in a while.
Yeah. Well, I guess I'd say at this point, there is no rush on the order of affiliation. I'll give him, what we'll do, Ms. Paisno, I'll have you renotice this for 2 weeks. And that way he can get an attorney if he wishes to do so. Obviously, there's substantial consequences if he is effectively defaulted. So if he wants representation, the court will give him an opportunity, but just renotice it for 2 weeks and then we'll take it up at that time.
And Leslie, were you aware that
Okay, so I'll read.
filed an objection?
I did. They filed an objection saying I didn't put anything in regard to custody in the order, but I can't until he's deemed dad.
Okay.
Okay.
But I did
well,
see the objection.
maybe we can address that too at that time and get things taken care of.
So you said to renotice it out for 2 weeks?
Yes, 2 weeks.
Okay, I will do that.
Okay, thank you.
You're welcome.
63 CB Kalamazoo Baseball LLC, Serial City Baseball LLC versus Orbit Marketing and Climax Insurance Agency LLC. Today.
Court will note the appearance of Mr. Carr on behalf of the plaintiffs. Mr. Carr, I do note when we look into the file, we didn't have a proof of service of the default. Did you serve the default on the defendants?
Yes, and I can get that. I was thinking we had filed it, but I can get it to you again, Your Honor.
That's fine. If you would just file it so that we have it in the file. Have you had any response from any of the defendants?
They're giving us a good leaving alone, Judge. I
Okay.
think you and I have scared them. So,
Well, I think it's more you than me. Court will note that it is now 9:35 a.m. It was set for 9 o'clock. Defendants have not appeared, have not taken any other action in this matter. The court will enter the default judgment as submitted, find that it's properly noticed, and we have no response. So the court will enter that, Mr. Carr, and you can get that from the clerk sometime today or tomorrow.
okay, Judge, thank you very much.
Okay, thank you. Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. McKenzie on behalf of defendant. The matter is before the court on the plaintiff's motion to compel answers to interrogatories. I guess, have you, Ms. McNiff, you've seen Ms. McKenzie's response, have you?
I have.
Okay. Well, a court does note that the defendant does have a right to assert a privilege pursuant to Michigan Court Rule 2.314 parens B parens 2. However, the defendant then cannot introduce any evidence relating to the party's medical history or mental or physical condition in this particular matter if she asserts that particular privilege. The court will also advise the plaintiff, should she intend to do so, that the court can then infer that the barring of this information would be detrimental to her case as to the factor of the physical or mental health and could hold that factor against her. Anything else, Ms. McNiff?
No, Your Honor.
Ms. McKenzie?
No, thank you, Your Honor.
Okay, thank you. Ms. McNiff, if you want to prepare an order to that extent, you can do so and submit under 7 days.
I will. Thank you, Your Honor.
Okay, thank you.
Thank you, Your Honor.
1 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff. This matter is before the court on the plaintiff's motion to modify custody and support. Court notes that it is now 9:52. It was set for 9:30. The defendant has not appeared, nor has the defendant filed any pleadings in this matter. The court will find that based upon the pleadings, there's sufficient threshold for an evidentiary hearing pursuant to Varka. The court will also order counseling for the children, with each of the parents to pay 1/2 of the counseling. And I don't know, you had also a request on child support, Ms. McNeff?
Yes, and I think that could be taken care of at the evidentiary hearing.
Okay.
The issue is the dad just simply hasn't gotten any parenting time, but he's given overnights in the order, in the calculation.
Okay. The court will refer that matter to the referee for evidentiary hearing as well. And if you want to do a separate order on counseling, Ms. McNeff, that would probably be appropriate.
Thank you, Your Honor.
Okay, thank you.
Thank you.
For 9:55 a.m.
Court will note the appearance of Mr. Vanderhorst on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for entry of the qualified domestic relations order. Mr. Vanderhorst.
Thank you, Your Honor. Parties were divorced on October 17, 2023, and pursuant to the judgment of divorce, a qualified domestic relations order was prepared by Quadro Express that accurately reflects the provisions of the judgment of divorce. Plaintiff is requesting that the court sign the Quadro so it can be processed by the plan administrator. The Quadro has also been pre-approved by the plan. So what we need is the court to sign it, and also if the defendant is willing to sign it, but based on the reading of the judgment and the Quadro that was prepared by Quadro Express, it does seem to be accurate. Thank you, Your Honor.
Okay, thank you. Ms. West, what's your response?
I have offered multiple times to sign it if I can get confirmation that the judgment of divorce is what's going to be upheld, because the way I read the language, the JOD that we all signed states that the value, he'll receive 50% of the value less the loan balance. The Quadro states that the loan balance as of the valuation date will be excluded. Those seem like contradicting statements.
Okay, Mr. Vanderhorst.
Thank you, Your Honor. Based on my reading of the pension retirement paragraph in the judgment, based on what Quadro Express prepared, it does seem that the because in the judgment, if you read it, it says the plaintiff shall receive 50% of the value less the loan balance of defendant's 403B held. So any outstanding loan balances as referenced in the Quadro, it said the valuation date shall be excluded when determining the alternate pays allocated benefit. So I believe that portion is accurately reflected in the Quadro.
Okay. With that, Ms. West, any response? Why is West not in?
I think we just still are differing on how that line is read. It's the value less the loan balance he gets 50% of. It's not 50% of the balance leaving me with the full loan.
Let me see. Well, he does have a provision under paragraph 7, talks about receiving 50%, and then it says any outstanding loan balances on the valuation date shall be excluded when determining the alternate pays allocated benefit. They're taking into account the loan balance then.
If that's how the court reads it, they're going to take the $26,000 that was sitting there, reduce it by the $10,000 loan, and Kevin gets half of the remainder. Then I've already said to Mr. Vanderhorst, I would sign it if somebody will just confirm that's how this is being read.
Okay, well, the court reads it that particular way, so the court will sign the Quadro as submitted. If in the future, Ms. West, it should determine that they attempt to review this, or if they attempt to implement it in a different way, you have a right to come back to the court and we can correct it at that point.
Okay, I appreciate that, and I thank you for your time today.
Okay, thank you. Free to go. Have a good day.
Thank you, Your Honor.
Court would note the appearance of Mr. Todd on behalf of the defendant. This matter is before the court on the defendant's motion for change of domicile. Court will note that it is now 10:08 a.m. The matter was set for 10 o'clock. The plaintiff has not appeared, nor has the plaintiff filed any responsive pleadings. The court would note that pursuant to Spears versus Bergman, that the court held that MCL 722.31 is not applied to a parent with sole legal custody, and pursuant to Michigan Court Rule 3.111(c)(1), the court must determine whether the party has sole legal custody and need not then consider MCL 722.31, which the court would note is accurate in this case and consistent with the court's prior rulings. The court will therefore grant the motion for change of domicile. Mr. Todd, have you submitted that, or do you need to submit under 7-day?
I'll submit that under the 7-day, Your Honor.
Okay, thank you. That will conclude this matter. You're free to go. Have a good day.
Thank you, Your Honor.
10:31 a.m.
Court will note the appearance of Mr. Magnuson on behalf of the front of the court. This matter is before the court on the defendant's motion to set aside default and default judgment. Mr. Carmucci.
Yes, sir.
Go ahead. Go ahead with your motion.
Yeah, I just want to set aside the default because I really just want a DNA test. I don't even think the kid is mine. That's the main thing.
Okay.
I have 6 other children, and I pretty much know.
Okay. Mr. Magnuson, any response?
Well, just from a purely legal standpoint, Your Honor, I know the court's familiar with the procedural history of this case. Everything was done appropriately as far as obtaining the default. Service of process in this case was done by alternate service per the court's order. We noticed the matter for a hearing. Defendant failed to appear at that. So I would say procedurally everything was done correctly. So I think bottom line, my position is that the default should not be set aside and that the order should remain in place. Now, that being said, if the court were to order genetic testing, I would not contest that or put up any opposition to that.
Okay, thank you. Ms. Rose, any response you have? Ms. Rose, any response?
No.
Okay. Well, what the court will do is the court, I'm going to reserve on the motion to set aside. What I will do, Mr. Carmucci, I will grant the order for genetic testing. So you can be in touch with Mr. Magnuson at the front of the court's office. He will set up the testing and then we can do the testing, because if the testing comes back positive, then there's no reason to set aside the default or any of that. So what we'll do is we'll just reserve on that and then proceed based upon what the test is. Okay, anything else?
So the court is ordering genetic testing at this time?
Yes, correct.
Very good, Your Honor.
And Mr. Magnuson, you can handle that through your office and then we'll.
Can you have attorney doing this?
Very good.
Yeah, if you could, Mr. Magnuson, if you'd prepare that order for genetic testing, we make sure we get it correct.
Yes, Your Honor.
Okay. Okay, then you'll be notified of when you have to appear and when we're going to have the testing done, and then we'll get the results and then we'll be able to determine how if we proceed further. Okay?
Thank you, Your Honor.
Thank you. Court will note that this matter is before the court on the defendant's motion to set aside referee order in this particular matter. I do note, Mr. Bard, you stated in there that your income was wrong and that your child, autistic child, prevents you from working. Is there anything else? Because quite frankly, what you have to do in these matters, you have to establish that there's a factual or legal error that the referee made, not just that you don't like the result or anything.
No, because I made this motion again because last time you stated that I needed doctor's records. So I sent in doctor's records indicating my youngest son is autistic, his autism report, and a lady named Cameron, she redacted the date of birth on the chart and redacted the date of the portion of my food benefits with he is in. She said it will become public records and anyone could come in and get that information. So I didn't send in all of the documents I had. He's also in ABA therapy Monday through Friday between 8 a.m. and 12 a.m. And then I pick him up and then he goes to elementary school from 12:30 p.m. to 3:30 p.m. So it will only give me time for a part-time job. And I've been applying for jobs because of my schedule that's available. Nobody has been calling me back. And I recently applied for Amazon Flex, but they just said that they're gonna add me to the waiting list because they are full. My youngest son, his mom abandoned him 3 years ago, so that made me a full-time parent to a kid with a disability. And after my grandmother passed December 1st, I mean, it's been really hard for me. That's why I was saying that those calculations are wrong. Those are from 3 years ago. And Miss Hale texted me saying that she was going to be here today. And I could text her right quick so she come in because she agrees with my terms. I mean, I have my son Logan like 50% of the time. Like I get him every weekend and I get him every time he's off for school. I take him to his basketball games, football games. I definitely am in his life like 50% of the time.
That's not an issue, sir. You were at the hearing, weren't you, before the referee?
Yes, and he asked me the last time I received income, and I told him that was 3 years ago. But I told him my situation now, and I received SSI, I received Medicaid, I received food benefits, and like I said, I'm trying to find a part-time job. That's why I was saying that, because before my monthly net income was the amount I had to pay child support was only 150. So I didn't understand why did it go up to 350 when I'm telling you guys that this stuff is from 3 years ago. I would rather it go back to the 150 and I could try to start paying that, considering
I
that.
understand that, sir, but what happens at those hearings, when you seek to have support modified, they can modify it the other way. They don't have to modify it just the way you want it. If the referee finds that there's a basis to, again, modify it in the opposite direction, they can do that.
He was saying, he was agreeing with me. He said RIP. He said he sent his condolences for my grandmother, the whole nine. Like he wasn't. He also was telling me that he was thinking it was going to go down. When I talked to somebody else, an assistant or something, she said that she was the one that modified it to go up based on the 3 years ago thing. That wasn't his doing. That was her doing.
What I'll do, sir, is based on this, I'll refer the matter back to the referee for additional hearing.
Thank you.
And
I appreciate it.
they can look at it at that point to see if maybe there was an error and they didn't understand. You're going to have to make sure you go to that hearing that you're very clear on what you're saying.
What is the date of the hearing, sir?
I don't know. The referee will set that and send you notice.
Okay, I appreciate that. Thank you, Judge Kirk.
Okay, thank you. You're free to go. Have a good day.
You too.
Please connect to audio. Roy? Can you hear me, Roy? Please connect to audio.
Court will note the appearance of Ms. Podolsky on behalf of the defendant. This matter is before the court on the plaintiff's motion for 50-50 custody. Mr. Clark, you state in your motion, and I quote, "I want 50-50 custody," end quote. You've not put anything else in the motion. Is that accurate?
I didn't know I was supposed to put anything else. I thought you told me to go with my motion. My first motion. That was the first motion I was going with.
Okay. Well, the court notes that there was a temporary order entered back on March 14, 2024. Ms. Podolsky has stated that you've not asserted any proper cause or change in circumstances for the court to entertain setting aside the temporary order, which is accurate. You have a right, because we're still in the course of these proceedings, you have a right to dispute custody, but you do not provide any basis in the motion for the court to change the temporary order. What would be
what?
What?
As in what?
Well, as in, I can't give you legal advice, sir. When you represent
No, I don't want
yourself,
legal advice.
you have to file the proper pleadings, and
I thought that was the proper way.
Excuse me?
I'm confused. I thought this was the proper way.
Well, you have to
This was the
file a
first
motion,
motion.
yeah, filing a motion, but there's things that have to be in the motion for the court to entertain your motion, and you haven't. Just saying what you want isn't a basis for the court to grant it.
So saying I want 50-50 custody is not enough?
That is not enough, sir.
So what? I'm confused. What am I supposed to put on the paper? Do you want me to say full custody?
No. What I'm saying is that if you file a motion, you have to set forth the basis for the motion. And
I'm sorry,
the
I don't know
basis
the
for a
basis.
motion
I don't know
isn't that
what
you
you're
just
speaking on.
want what you want. The law requires that things be in motions. In this case, there's a case called Babarka versus Grassmeyer, and it says that if you're going to change custody, you have to show proper cause or change in circumstances, which you haven't even alleged in your motion.
Sir, how can I change the circumstances if I was never... I thought you granted her full custody because y'all claim I didn't show up to court.
On a temporary basis. It's a temporary order, sir. You still have the right. You still have the right to... Sir, don't interrupt me. I'm trying to tell you what you need to do. I can't if you're going to...
I'm trying to get up.
Don't interrupt.
So you can understand me better.
Sir, don't interrupt.
All right. I'm confused, bro.
Well, you are. I'm saying there's a temporary order. you have a right to contest custody as the case proceeds by filing the proper pleadings in the case. Okay?
How do
Not-
I file the
Okay.
proper pleading?
Well, you're gonna have to get legal advice then, sir. You'll have to contact an attorney, get some legal advice or something, because it doesn't sound like you're able to do it on your own. So there is no basis to set aside the temporary order. So the court will deny the motion at this particular time. Ms. Podolsky, you can submit an order denying the motion under 7-day.
Thank you.
Okay, thank you. That will conclude this matter. You're free to go. Have a good day.
Thank you. You as well.
Plaintiff is via telephone.
Okay. Mr. Osborne, I'll go to you first because you are the plaintiff in this matter. And the scheduling conference is whereby we attempt to put in place various dates and procedures so that the case will proceed in an orderly fashion. But to do that, I want to find out what issues are in dispute. So I'll ask you, sir, what issues do you believe to be in dispute in this case? Mr. Osborne?
Your Honor, Miss Osborne is the plaintiff. Maybe that might be why she's not answering.
Oh, I'm sorry. I'm sorry. Okay. Miss Osborne?
Yes, Your Honor.
What issues do you believe to be in dispute?
Well, I'm not really sure. I've never been divorced before, so this is all new to me. I heard this was over child custody, which I want full custody of Paisley. This is the home she grew up in. She's a special needs child.
Okay, I only need to know the issue, ma'am. I only need to know the issues, not the background in it, because we're just finding what the issues are that are in dispute.
Okay, to dispute.
You're saying custody.
Yes, custody,
Okay.
absolutely.
Okay, Ms. Bailey Hobbs, maybe you could fill me in. Any other issues in dispute?
Thank you, Your Honor. I would say that probably all of the issues are currently in dispute. With regard to the child, we would have issues of custody, parenting time, child support, paternity, I believe is the only issue that is not in dispute. Regarding.
Okay, are there property disputes?
Yes, Your Honor.
Is there spousal support disputes?
I don't know. My
Yes.
client did not plead spousal support,
Okay.
but Miss Osborne may have. I don't have that up right now.
Ms. Osborne, did you plead request for spousal support?
Yes, sir. Yes, Your
Okay.
Honor.
Okay. We will mark that down then. Are we looking at, are you going to need time for discovery, Ms. Osborne?
Time for discovery?
Yes.
Can you explain that to me? I'm sorry.
Okay. Well, let me
I don't
ask
know
Ms.
your
Bailey
jargon.
Hobbs if she needs discovery, and then I can explain it. Ms. Bailey Hobbs, are you
Okay.
looking for a time for discovery?
Your Honor, a little bit of time would be good, but I don't think that discovery is going to be a huge component.
Okay. Ms. Osborne, what it is discovery is the time whereby you can acquire information from the other side. You can do that through interrogatories, which are questions that need to be signed under oath, requests for production of documents, requests to admit. You can do depositions, anything that you might need for getting information from the other side.
Okay.
What I'll do is I'll put down June 1 as the discovery cutoff date. What that means, ma'am, is that you're going to have to do whatever discovery you have, you're going to have to do it before June 1, or you will not be allowed to have any. You understand?
I'm trying to understand. If I don't do it by June 1st, I won't have any discovery.
Right, that's correct.
And discovery again means what? I'm sorry. Your Honor.
Acquiring
Means
information from the other side through the processes that I mentioned.
what? Okay. I don't know what to say to that. I want full custody of her.
Okay,
And
I'm aware of that.
I don't
You
know
mentioned
about I don't know what other information I would get from the other side. So I'm not.
Well, I don't know either. That's up to you. So if you need it, you have to do it by June 1.
Does this mean if I feel that he's not a fit parent?
No.
I need to show you? Okay.
Nope. It means, let's say, for instance, you were not certain for child support and you needed to get his income. You could acquire that through, again, the processes that I mentioned, or you could subpoena the employer, or you could do any myriad of other things to try to get that information.
Okay, yes, there are ways. I am going through files now, and I'm finding that Mr. Osborne makes way more than he's claiming.
All I'm talking about this is not any disputes that you have at this point.
Okay,
Okay, so if you need to acquire that information, you have until June 1 to do it.
okay. Yes, thank
Okay.
you, Your Honor.
Court will set mediation for the month of June. Ms. Osborne, I assume you don't have any attorney mediator that you're aware of to handle the case, do you?
Did you say Miss Osborne?
Yes.
No, my attorney will be in the next hearing though. I'm in between right now.
Okay.
So I'm not
Ms.
being represented today, so this is kind of a struggle for me.
Ms. Bailey Hobbs, do you have any recommendation for a mediator?
Your Honor, I would recommend attorney mediator Michelle Woznicki as the mediator for this case.
Okay. Ms. Osborne, do you have any problem with Ms. Woznicki? Or
Who is she and how did you choose her?
well, she doesn't have to disclose that. She just recommended that person. You have a right, if we name that person, that you can research it, and if there's some issue that you have with that, then you can always bring that up at a later point. So.
Okay, and she is a mediator?
She's an attorney mediator, yes.
Okay, all right, and her name again, please?
It's Michelle's her first name, isn't it?
Yes, Your Honor.
Michelle Woznicki.
Woznicki.
Yep.
Okay, thank you, Your Honor. Yes, I would definitely like to look into her first.
Okay. And if she's not able to, Ms. Bailey Hobbs, do you have an alternate that you recommend?
Let's put attorney mediator Colleen Lennon.
Colleen Lennon? Your Honor, was that Colleen Lennon?
Yes. Okay.
Okay.
And that's just if Ms. Woznicki would not be available or had some conflict or something like that.
Okay. All right.
The court will set July 8, 2024 at 1:30 p.m. as the settlement conference date. Parties are required to be present unless we've come to a full agreement prior to that time.
Okay, so we have another meeting, Your Honor, July 8th at 1:30, you said?
1:30, correct.
Okay, and this is for settlement?
Settlement conference.
Settlement conference, okay.
Now, I would tell you, Ms. Osborne, until such time as you have an attorney, make sure that you review the scheduling order, because there are dates in that scheduling order as the things that you must comply with at that time. If you do not comply with them, then you risk not either having a witness be able to be present and testify, or to introduce exhibits or anything of that nature. So pay attention to the dates that are in the case scheduling order so that you don't run afoul of that.
Okay, I have been checking with Safe Place. They're very familiar there. I've had to leave the home and stay there many times. And they are helping me out, and they are also helping me get with legal services to help.
Okay, that's fine.
They have a huge file on what's going on in this marriage. So it would help, yeah. Yep.
Okay,
So I will have my attorney next time.
Okay.
And I will have to keep up with these dates.
This order will go out either today or tomorrow. You should have it by the end of the week. And again, just comply with the orders. Anything else, Ms. Osborne?
Well, I have not seen child support yet. I don't know when that starts. Like I said, I'm new to all this.
Okay.
I have not received any money for my daughter.
Okay. Well, we're not dealing with that today, ma'am.
Okay.
We're just dealing with the
Yes, sir.
scheduling order.
Okay.
Okay.
Okay. Thank you.
Ms.
Thank you,
Bailey,
Your Honor.
Ms. Bailey Hobbs, anything else that you have?
I have nothing, Your Honor.
Okay. Thank you. Well, you're free to go. Have a good afternoon.
Thank you. Have a good day.
Thank you.
Attorney McNiff.
Thank you,
for
Judge.
the
Bye-bye.
plaintiff.
Bye.
All right,
Okay.
let's go.
Good afternoon to all of you. I will note this matter is before the court for status conference, and Ms. McNiff has asked that we would put in place a scheduling order in this matter. Sir, a scheduling order is whereby the court puts in place various time deadlines and procedures so that the case proceeds in an orderly fashion. So the court is prepared to do that, I'll go to the plaintiff first. Ms. McNiff, what issues do you believe to be in dispute?
I believe that we have parenting time, child support, and some property distribution.
Okay. Sir, are there any other issues you believe are in dispute in the case?
I don't believe so.
Okay, are you disputing custody or anything else?
Not at this time.
Okay. So the court will put those 3 items down. Ms. McNiff, are you in need of discovery in this matter?
I don't believe so. We've exchanged verified financial information. I've done some discovery already. I think mediation might help.
Okay. Why don't we just set the discovery deadline for May 1? That gives you a little time. If you need it.
Perfect.
Sir, discovery is a process whereby you can acquire information from the other side if there's something that you need. So if you have to do that by May 1, okay?
Okay.
The court would then set mediation for May. Ms. McNiff, who would you like as the mediator?
Mr. John Brundage.
Okay. Sir, do you have any problem with Mr. Brundage serving as mediator?
I guess not.
Okay. And as an alternate, Ms. McNiff?
Ms. Podolsky.
You have a problem with Ms. Podolsky serving as a alternate?
No, Your Honor.
Okay. Thank you. Court will do that, and we will set June 10th at 1:30 p.m. as the settlement conference date.
Great.
Sir, I will tell you, because you're not represented, that in this scheduling order are various dates of things that you must comply with. And so when you get the order, make sure that you look it over, make sure that you comply with those dates, because if you don't, it could have serious repercussions on your case if you don't get some things filed. Okay?
Okay, Your Honor.
Anything else, Ms. McNiff?
No, Your Honor.
Mr. Baker?
I don't know if I can do it here, but what do I have to do to request, like, communicating through a court appointed app?
Oh, well, the court doesn't have any apps, but there are various apps that are available for communication.
Okay. I believe that would be best moving forward.
Okay. What are your thoughts, Ms. McNiff? Is that something we should put in place, or?
I don't have any problems with using Our Family Wizard, or if the parties find that too expensive, we could probably find one that's free or at a reduced cost.
Okay. Sir, you understand, if we did it through Our Family Wizard, there's a cost associated with that. You'll have to, basically, the court would order that parties would each bear 1/2 the cost of that.
Okay.
Okay.
Or potentially look at alternative.
Why don't you put or Ms. McNiff, if you could do an order just saying that they're going to communicate through Our Family Wizard or any other app as mutually agreed by the parties.
I can do that.
And I will tell you, just so you know, but for both parties, that those services do keep track and keep a log of those communications. So if somebody's saying things that they shouldn't say, or let's say making threatening communication, that the court will have access to that and know what you did and when you did it. So you have to, when you're using those, you have to be on your best behavior. Okay. Anything else, Ms. McNiff?
No, Your Honor.
Mr. Baker?
No, Your Honor.
Okay. Thank you. Court will conclude this matter. You're free to go. Have a good day.
Thanks, Judge.
You too. Thank you.
Attorney
You're just going to pop me back into the waiting room?
for Attorney Willis for plaintiff and Attorney Stroud for the 2 defendants.
Okay. So I don't mess up. You are Attorney Willis, is that correct? Or
Yeah, Willis Law. My name is Austin Bodette, Your Honor.
Bodette. Okay. Sorry. I almost messed it up again. Okay, Mr. Bodette, enlighten me. What's happening in the case at this point?
Yeah, so the parties have engaged prior to suit in some initial settlement discussions. We couldn't agree to a final number, and this lawsuit ensued. We've been working on a joint status report, and we've been discussing potential mediators for the case as well. And we will be filing some initial discovery here in the next week or so.
Okay. What the court will do is the court will give you about 14 days to arrive at a mediator. If you don't, then the court will just randomly assign a mediator.
Okay. Yeah, we will discuss. I'll discuss with opposing counsel, and we'll see if we can agree on somebody for the case.
When you do, please contact our office. Let us know that you have arrived at a mediator and who it is.
Of course.
Okay. Mr. Strout, anything that you have in this matter?
The only comment I'd make about what counsel just said is that I have not been involved in settlement discussions that must have gone on before my watch.
Okay. Well, that's fine. They didn't say they settled on anything, so.
No, I know. I am a little worried about expectations, though. Be that as it may, I have one question. There is a ex parte case scheduling order that provides that pleadings may be amended only by leave of the court. I am within 14 days of my answer. Am I free to file an amended answer if I want to?
Yes, you can file an amended answer.
Okay. I don't think I really have any other questions. We talked about picking a mediator. We talked about a joint pretrial statement. Counsel mentioned discovery. I have not seen a plaintiff's disclosure yet. Is there one coming?
That will be coming this week as well.
Okay, good.
Okay, well, good. Keep us apprised of what's happening with the mediation, and then you have some other dates coming up on that for a lot of different things in this and the settlement conference date as well. So we will let you go and not keep you any longer. Have a good afternoon, gentlemen.
Okay, thank you, Judge.
Thank you, Your Honor.
Hints for plaintiff, and one of the defendants is here.
Okay. This is a status conference in this matter. I'll ask you, Mr. Hintz, what's happening in the case and where are we at?
Thank you, Your Honor. John Hintz appearing for the plaintiff. And Mr. J. Cox, Brandon J. Cox, who's the registered agent for Family Ties Construction, LLC, has been in contact with me regularly, Your Honor. And we've been talking, we've been attempting to resolve this matter, and settlement offers have been exchanged. He has given me one on behalf of the business, and Lawrence J. Cox, and I may be speaking out of turn, Your Honor, and I apologize, is his relative, and he had signed the personal guarantee. Mr. J. Cox, I'm informed, is not in good health and was not able to be here, but Brandon J. Cox, who is the registered agent of Family Ties Construction, can certainly speak. He's been forthcoming with me, and we are putting together a settlement arrangement, Your Honor, to resolve this matter.
Okay. Mr. J. Cox, is that your understanding what's happening?
Yes, Your Honor.
Okay. What I'll do is, as you're trying to come to a resolution, I'll let you know that we're going to give you 14 days to arrive at name of a mediator to mediate this matter in the event that you're not able to come to an agreement.
Yes, Your Honor.
So if you can't come to an agreement in that 14-day period, then at least come to an agreement as to who will mediate the matter. And then when you do, Mr. Hintz, if you'd contact my office, let us know when you're going to be mediating and who the mediator is.
I will do so, Your Honor, and I will be preparing some documentation to send to Mr. J. Cox, for everyone to sign, and we will get that to you, Your Honor.
Okay. Mr. J. Cox, is there anything that you have at this point that?
No, Your Honor.
Okay. And Mr. Hintz, anything else?
No, Your Honor, not at this time. I will be submitting paperwork.
Okay. Thank you, gentlemen. We'll let you go. You have a wonderful afternoon.
Thank you, Your Honor. I'll be in touch, Mr. J. Cox. Thank you.
Attorney McNiff for defendant. Defendant is here via telephone.
Okay. Mr. Parrott, I'll go to you first as you represent the plaintiff. I've been advised that you did settle all child-related issues at mediation, but not property division. Is that accurate?
To my understanding, Your Honor, that's
not accurate. I was asked to handle a pro-con today.
Okay,
That's correct. We have settled all of the property issues, Your Honor.
okay,
We settled them after mediation, but we've been negotiating up until last week.
okay. That's just what I had in my notes, is that you hadn't, but we didn't have that other information.
We have good news for you, Judge.
Okay, great. Well, I
Although
have
very bad news.
Yeah, I have some bad news for you, Ms. McNiff, is your client has not paid the mediation fee as of yet.
Oh, generally we take care of that, so I'll make sure my office staff does that.
Okay, okay,
Well, as of last week when I was preparing these.
Yeah.
So,
okay, please take care of that then. Mr.
Uh,
Perk, what we'll do is have, Mr. Lewis, we'll have Mr. Lewis raise his right hand, we'll have him sworn in, we'll take some proof.
Thank you, Your Honor. Mr. Lewis, can you state your full name and address for the record, please?
Yes, Michael Quinn Lewis, 100.
Mr. Lewis, you came to the law firm of Butler, Towson, and Paisno sometime in 2023 for purposes of filing a complaint for divorce in a matter against Rebecca S. Lewis. Is that correct?
Yes,
And a complaint for divorce was prepared and was provided to you for your review. Do you recall that?
yes,
We made certain allegations in that complaint for divorce that were representations to the court that the facts asserted therein were true and accurate to the best of your information, knowledge, and belief. Do you remember that?
yes, yes,
And do the facts that were alleged in the complaint, were they true at the time you filed the complaint?
yes,
And do they remain true today?
yes,
Okay. You have alleged in the complaint that on or about October 6, 2001, that you married Rebecca S. Lewis in the city of Battle Creek in the state of Michigan in a marriage ceremony before somebody who was authorized to perform marriages. Is that true?
yes,
At the time your wife married you, her name was Rebecca Sue Corkwell. Is that correct?
yes,
And she took your name, Rebecca Sue Lewis, after the time you were married. Is that correct?
yes,
At the time you filed the divorce complaint, had you resided within the state of Michigan for a period of not less than 180 days immediately preceding the filing of the complaint?
yes,
And had you resided within Calhoun County for a period of not less than 10 days immediately preceding the complaint?
yes,
My understanding is that you and Mrs. Lewis have one child, Lauren, approximately 14 years old now. Is that correct?
she's 15, but yes, one minor
Okay,
child.
very good. Okay, and you have, in relation to issues of custody, parenting time, and all other ancillary issues related to the minor child, have settled all those matters in accordance with the terms of an agreement with Miss Lewis. Is that correct?
That's correct.
Okay, and do you believe that agreement to be in the best interests of the minor child?
Yes,
Okay, and is your wife currently pregnant?
no,
Okay. You've alleged in your complaint that there was a breakdown of the marriage relationship to the extent the objects of matrimony were destroyed, and that there remains no reasonable likelihood that the marriage could be preserved. Is that true?
that is true.
And could you briefly explain to the court, you don't need to get into details, but briefly explain to the court what precipitated the filing of your divorce complaint?
We just didn't love each other anymore. There was too many differences that we couldn't put aside.
Okay. And during the term of your marriage, you accumulated various other property items that have now been allocated pursuant to the terms of a property settlement that Ms. McNiff spoke of previously. Is that correct?
Yes,
And once encapsulated within a judgment of divorce, you're asking this court to enter a judgment for this court's consideration. Is that correct?
that's correct.
And you're doing so based upon the belief that if this court were not to enter the judgment of divorce, you and your wife would not resume cohabitating as husband and wife. Is that correct?
We would not, correct.
Okay. Your Honor, I have no further questions.
Thank you. Court will find that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the approved judgment and UCSO. Sir, you're not divorced until I sign the final papers. That still may take a couple weeks yet. So, but at that time, I want to wish you best of luck. I hope everything works out for you, and the court will end these proceedings. You're free to go. Have a good afternoon.
Thank you, Your
Good
Honor.
afternoon, Judge.
All right.
Ms. Henderson, Ms. Podolsky did contact us earlier, say that you have a consent judgment, that she was not going to appear. You're simply going
correct, Your Honor.
to take proofs. Is that correct?
Yes, Your Honor.
Okay. Mr. Blatchfield, I'm going to have you raise your right hand. We'll have you sworn in and we'll take some
Not the
testimony.
truth.
I do.
Okay, go ahead, Ms. Henderson.
Thank you. Mr. Blashfield, could you please state your full name and spell your last name for the record?
Daryl Scott Blashfield.
Did you consult with me regarding filing for divorce in late 2023?
I did.
And did I in fact prepare all the documents necessary to initiate the proceeding on your behalf?
Yes.
Prior to signing the complaint for divorce, did you have a chance to review it?
Yes.
Were all allegations therein true and accurate at the time that you signed the complaint?
Yes.
Do they still remain true today?
They do.
At the time of filing for divorce, have you resided in Calhoun County for 10 days and the state of Michigan for 180 days?
I have.
Is your wife currently pregnant?
No.
In your complaint for divorce, you have asserted that there has been a breakdown of the marital relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage could be preserved. Could you please briefly state to the court the reason for the breakdown of your marriage?
Tricia and I drifted apart over the years, very big differences in our views on finances and careers and future goals.
Is it true that you and Mrs. Blashfield have reached a settlement regarding all child-related issues as well as property and debt?
We have.
Is it also true that you and Ms. Blashfield have signed a judgment of divorce that I have prepared?
We sure have.
And to your knowledge, has the friend of the court approved the documents?
Yes.
Thank you. If the judge were not to grant the divorce upon the expiration of the time frame, is there any reasonable likelihood that you and Ms. Blashfield could go back to living as husband and wife?
No.
May it please the court, Your Honor?
Court is satisfied that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. Sir, you're not divorced till I actually sign the judgment in that. That's gonna take about 43 days because that's the waiting period. So as soon as that time is up, then we'll be able to enter it. You'll then be divorced. And I would say best of luck to you, sir. I hope everything works out for you.
7 p.m.
And you're free to go today. Have a wonderful day.
Zubik filling in for Attorney
Your Honor.
Neff for plaintiff and Attorney Todd for defendant.
Good afternoon to everyone.
Afternoon.
This is a time and place set for a settlement conference, and I guess I've been apprised at least that mediation was successful and the case is settled. Is that correct, Mr. Zubik?
For the most part, Your Honor. However, there was still one issue that we could not settle on.
Okay, and what was that?
That was regarding the no contact with the friend of Brooks.
Well, they didn't, we weren't informed of that. So, Mr. Todd, what's your position?
That's correct, Your Honor. Everything has been settled outside of the no contact of somebody by the name of Mr. Mark McKediak. He has had multiple convictions, multiple felonies, methamphetamine conviction, assaulting a pregnant individual, second offense, 8 convictions in Michigan only, including a felonious weapon charge. And the temporary order includes that he would not have contact with the children. So at this point, that's the only issue in dispute. And I'm not sure if Your Honor wants to do a motion hearing or.
Yeah, bring that back in. Bring it in on a motion hearing. I can address that. We do have some time. We're only at 119 days, so we have some time to get that resolved.
Sure. Yep.
Okay.
Yeah, I can file a motion on that, and then I think that probably resolved the need for a full-blown trial.
Okay, good. Mr. Zubik, what we'll do is, why don't we do that as long as we're waiting? We take some proofs today. And Ms. Edwards, we're going to take some testimony from you. So if you would raise your right hand, we'll have you sworn in.
I'm sorry, are you talking about proofs in regard to what's been settled?
No, as to the divorce. Pro-confessor, with a testimony for a pro-confessor hearing.
I'm sorry, Your Honor?
I said the testimony that we take for a pro-confessor hearing.
Okay, I'm not sure I'm familiar with that, Your Honor.
Okay, I'll ask the question then. Ms. Edwards, in this matter, you filed a complaint seeking a divorce from the defendant. Is that correct?
Yes.
At the time that you filed that complaint, were all of the allegations in the complaint true and accurate?
Yes, Your Honor.
Do they remain true and accurate today?
Yes.
You stated in the complaint that you had resided in the county of Calhoun and the state of Michigan for more than 180 days immediately preceding the filing. Is that correct?
Yes.
Are you currently pregnant?
I'm sorry, what was that?
Are you currently pregnant?
No, sir.
You stated in your complaint that there has been a breakdown of the marital relationship to the extent the object of matrimony had been destroyed and there remains no reasonable likelihood that the marriage can be preserved. Is that correct?
Yes.
If the court did not grant a judgment of divorce, is there any chance that you and the defendant can reconcile and live together as husband and wife?
No.
The court will find that the testimony does establish the statutory basis. The court will preserve the proofs in this matter pending resolution of that last issue with a motion hearing and the preparation of a judgment of divorce, UCSO, and paperwork that's needed to complete the matter. So with that, you're not divorced until we actually sign that paperwork. You're still looking at a couple months before we can get that entered. But at that time, you won't have to come back in and we'll be able to get it resolved. And at that time, you would be divorced. And so I'll tell you at this time, best of luck to both of you. I hope everything works out for you. And for today, you're free to go and have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.